I'm Robert Falanga from the law offices of Falanga and Chalker. Today I'm here to talk to you about you've filed your personal injury lawsuit, your attorney contacts you and says you need to come in for a deposition. Right away you freak out and you don't understand what a deposition is or what you're supposed to do or what you're not supposed to do. So today I'm going to give you 9 tips on what to do during your deposition while your deposition is taking place. The first tip is that you need to dress accordingly. Remember, right now all you are is a name on a file to an insurance company. This is their first opportunity to evaluate you and what type of a person you're going to make in a courtroom in front of 12 jurors. So it's important to dress accordingly. Wear your Sunday go to church clothes. The first impression is the best impression. So look your best. Step number 2. You have a right when you have a deposition to read the deposition and sign it for accuracy. You can make an appointment with a court reporter and go down to their office and read the deposition and sign a correction sheet, and then it's notarized and you've had an opportunity to review it. Once you do that, you're locked in. You can't change anything in the deposition. Your attorney will advise you on whether you should reserve signature or waive your signature, but that's one of the things that will be involved in your deposition. We generally waive our client's right to sign and read the deposition for accuracy, because what you're really doing is you're reserving the right to do it at any time, up to and including when you go to trial. Step number 3, tell the truth. That's the most important thing. Remember, if you tell the truth, you never have to remember what you said. Step number 4, know and understand the question. I know that it's intimidating to you. You've got these lawyers with all this education and you got a lady taking down every word that you say as it comes off your lips. It's a very intimidating atmosphere if you don't do it on a daily basis. So the general thing is that you might not understand a question, but you don't want to feel stupid, so you answer it anyhow. Well, that's the stupid thing to do, because that's going to come back to haunt you. This is what they use to cross-examine you, to catch you, to try to make it look like you're fabricating your story when you go to trial. So it's important that you understand the question and think about it before you give an answer to it. Don't ever answer a question if you don't understand it. Tell the attorney, excuse me, sir, this is very important to me. I want to make sure I get this right. I'm not sure I understood your question. Could you please restate it or rephrase it? That's the proper thing to do. Step number 5, keep your answers short. Don't be volunteering a whole bunch of information, running on, rambling on about other stuff, because it's going to lengthen the deposition and you don't want to give up any information or lead them into other areas that they could go to find discovery to attack you with. So keep your answers short. The next thing is, if your attorney makes an objection, you need to stop what you're saying immediately and listen to what the attorney is saying in his objection. He may be signaling to you that you're about to get into some dangerous waters. So listen to the objection from the attorney and don't answer any further questions until the attorney says you may now answer. The next thing is, the attorney cannot help you in the deposition. You can't turn to the attorney and ask him, how should I answer this? It's your deposition. The attorney won't be able to help you whatsoever. The next thing is, you can always take breaks though. If you feel like you need to take a break and you want to talk to your attorney, you're entitled to take a break at any time. And remember, if you're here on a personal injury case and your neck hurts or your back hurts, it hurts for you to sit for maybe longer than 15 or 20 minutes, there's no rule that says you have to sit there stoically in front of the attorney that's questioning you. You can get up, you can walk around, as long as you stay in the room and answer their questions, that's all that's required of you. You can stand up and stand behind your chair and hold on your chair. You can walk back and forth where the table is. You can feel free to move about, but you have to stay in the room. But you do not have to be frozen to the chair that you're in. The last thing is, post-deposition interviews. Your attorney will take you after the deposition and have a post-interview session with you. The purpose of that is to obviously tell you how you did, what strengths or weaknesses you had in your deposition, what we need to work on for trial, what information came up that maybe the attorney doesn't have that we need to assign people or assign you to get and bring those documents to our office. And that's pretty much what you should do, and you'll get through your deposition, I promise you. Remember, at Felenga & Chalker, we'll work hard to get you every dollar that you're entitled to in your personal injury or wrongful death claim. If you can't come to us, we'll come to you, and the initial consultation is always free. Give us a call at the number that's on this video, or contact our webpage, which is also displayed there. Thank you very much. Good luck to you in your deposition.